The first order of business in the courtroom this morning was to settle disputes about what will be included in the judge's instructions to the jury. The defense objected to including an option for the jury to find George Zimmerman guilty of the lesser charge of manslaughter, but the judge agreed with the prosecution that Florida law requires that manslaughter be included as the lesser charge in a second-degree murder case. Back with me, MSNBC legal analyst Lisa Bloom. Also with me, former homicide prosecutor Ken Padowitz. Ken, I want to go to the importance of this fight this morning that got very tense over exactly what will be included in the judge's instructions to the jury. After the attorneys deliver their closing arguments, masterful or not, emotional or not, compelling or not, how important is the judge's instructions, what tends to come over as a very dry recitation by judges?
Well, the instructions are everything in this case. And there really wasn't a question in Florida as to whether or not manslaughter was going to come in as one of the instructions to the jury. If one side asked for it in Florida and there's any type of evidence that supports it, which there is in this case, manslaughter has to be read to the jury. So it really wasn't a good debate. But what's really important is to think about what a lesser included crime is. It's kind of like if you think about an upside-down pyramid. The top of the pyramid being second-degree murder, the charge that has been filed against Mr. Zimmerman, and then under that is manslaughter. It's subsumed within the higher crime. So the judge is going to tell the jury, you have to start with the highest crime, and if the elements have not been proved to you beyond a reasonable doubt, the next job is for you to go to the next lesser included crime of manslaughter. And here we know that second-degree murder, we're basically looking at depraved mind, ill will, spite, evil intent on George Zimmerman. But for manslaughter, the lesser included crime, it's one of two ways. It's either an intentional act that caused the death of Trayvon Martin, or it's culpable negligence. Negligence we usually think of in civil cases, but in criminal court, negligence has to rise to the level of being culpable. That means gross, wanton, reckless disregard for human life. And that's the key words, disregard for human life.
And Lisa Bloom, is that negligence standard met if you're in a fist fight and you pull out a gun?
Right. In other words, imperfect self-defense, sometimes that's called, or George Zimmerman panicked. He wasn't really in reasonable fear of great bodily injury or death. He was just panicked. He freaked out. He grabbed the gun and shot. Maybe he didn't have a depraved mind at that moment. Maybe he really was thinking about saving his life, but in retrospect, it was not reasonable. That would be manslaughter.
And Ken Padowitz, I think a lot of Americans are looking at this and kind of realizing, just anecdotally, based on their own experience, that if George Zimmerman, during the pursuit, when he was in the car, if Trayvon Martin had kind of tripped off the curb or something and the car had hit Trayvon Martin and killed him, that Zimmerman's conviction on some kind of vehicular homicide would be virtually assured. And yet getting out of the car and getting into some kind of encounter with him and then pulling out a gun could be a way of walking away as a free man, not guilty after killing him.
Right, and that's the defense here, is self-defense, that at the last few seconds, Zimmerman reasonably felt that he was in fear for his life or great bodily harm to himself and had to pull that trigger. But it's the prosecution's job to take a much wider view and to start from the point where Zimmerman is following, pursuing, stalking, has a gun, it's loaded, it's chambered with a round, he's disregarding the 911 operator. All these things can go to depraved mind for second-degree murder, but they also can go, and I think even stronger, for manslaughter to show a culpable negligence. It's really a disregard for human life. And when he places, you know, the kid in the corner who has to defend himself, who has to stand his ground and fight back for his life, that's when Zimmerman decides to pull the trigger. And that's why really it's a very strong argument for culpable negligence for a manslaughter lesser included crime, which is a very serious conviction.
Was actually the easiest part of this case to prove. You've got him on tape minutes before the shooting, calling him an effing punk, an a-hole. Do we think that during the fight he grew fonder of Trayvon Martin? Right. Immediately afterwards at the station, he's calling him a suspect and still implying he's a criminal. And 5 months later, he's saying he has no regrets and it's God's plan. What part of that is not ill will?
Well, Ken, if the manslaughter case is an easier one to prove, how do you defend the manslaughter case tomorrow? Because you're going to have to defend both of these.
Right, and the judge is going to read the instructions of self-defense both times. She's going to read it right after she tells the jury about the law for second-degree murder, and she's going to read self-defense again when she reads the manslaughter instruction. So the jury's going to hear that self-defense argument or the law from the judge twice, and that's the defense's job tomorrow in closing argument, to really show the jury, hey, there is reasonable doubts all over the place here, and there's a reasonable doubt as to whether or not George Zimmerman had to fire that gun to defend his life. And therefore, you know, you must find my client not guilty. That's going to be the argument that the defense is going to have to make here for both second-degree murder and for manslaughter.
But is the jury going to have a different standard in their heads for just the call on using self-defense when it comes to slaughter charge?
I know exactly what you're getting to, and the problem I have is that the jury has gotten this visual from both sides over and over again of George Zimmerman down, Trayvon Martin on top, pounding his head, punching him in the face. I think most people in that situation would say, if you had a gun on you, you could take it out and shoot it.
Not in my neighborhood.
Well,
that used to happen all the time, and nobody pulled a gun.
The prosecution needed to give the jury today an alternative theory, and they didn't do that. The defense has been very good with this one theory, driving it in over and over again, questioning with so many witnesses, putting that scenario in front of the jury. That is in their minds. The jury does not have an alternative. The prosecution should have stood up the dummy during the closing argument, showed how they could have been standing, put George Zimmerman on top, as a number of witnesses have said that he was. The prosecution failed to do that, and so the jury only has that one image. That's got to be a big concern for the prosecution.
Ken Padowitz and Lisa Bloom, thank you very much. Lisa, you're going to be back. Up next, a look at the 6 women on that jury who will decide to convict or acquit George Zimmerman.